Immigration attorney Sharifa Tharpe. I'm here live to talk about, give you an exciting update, and also to answer some questions that you may have regarding any kind of immigration issues. So, I do have good news. Yesterday, the Farm Worker Association of as well as the American Immigration Council and other immigrant advocacy organizations, along with interested immigrants, so undocumented immigrants and citizens who are being affected by the anti-immigrant law, filed a lawsuit against the Florida government, which includes DeSantis as well as the Attorney General here in Florida and other um, officials within the Florida government. And I believe that there's a very, very good chance that they're going to prevail in this lawsuit, meaning that the law could be stopped. I did some time today, and this is why I'm a little late, is I took some time today to really go through the complaint. The complaint is the document that's filed that initiated the lawsuit against DeSantis. And in the document, they have presented to the court that this law is unconstitutionally vague. Now, whenever we hear unconstitutional, what that means is that this law violates the law of the land, which is the Constitution. And it's unconstitutionally vague means that it is so unclear in its definition that it makes it confusing for individuals to follow, that it is too far reaching, it is too broad, and that it also affects the ability of the federal government to enforce the immigration laws themselves. So it infringes on the right of the government to do their job, because remember that immigration is the job of the federal government. It is not the job of the state. And this is one of the things that I have been trying to explain to you, is that the state cannot, for example, arrest or deport immigrants for being undocumented. However, this law is trying to do this. It is trying to carry out the enforcement actions of the government. And so I really think that because of this, it is going to fail. Now, there are a number of reasons that I took note of that allows me to come up with a conclusion that I would be very, very surprised if this lawsuit does not, they don't win this lawsuit. One is that there have been similar laws that were passed, anti-immigrant laws that were passed in Alabama and Georgia, which were preempted. So what that means is that those laws were found to infringe on the federal government's role to enforce immigration. So those laws or parts of those laws were not allowed to go forward. Well, this law is very similar. And keep in mind that these decisions were made by the 11th Circuit Court of Appeals. That is the court that's right under the Supreme Court. So they're a higher court, and so their decisions stick. It means that when they make decisions, it can be binding law. And so you have to look to the laws that are created by this higher court. And the higher court has said that similar laws that were passed in Alabama and passed in Georgia could not go forward, or part of those laws, because they were contradictory to the immigration. Now, this law, SB 1718 in Florida, it also affects the federal government's ability to enforce immigration law. It hinders their ability to enforce law, and I'll explain why. So, for example, they brought this up in the complaint to the court, the federal court here in Miami, that the USCIS, that's the agency that accepts. Sometimes they conduct immigrant check-ins, and they also do applications for individuals who are seeking immigration relief. And under the instructions of the USCIS, it does instruct certain immigrants to travel across state lines, to travel from Georgia into Florida to attend their interviews, to attend biometrics appointments, and to do certain check-ins. So when you have a law, which the Farmer Association, so the Farm Worker Association of Florida, they are they're asking the government, to the court, to put a stop to the Section 10 of the law. Section 10 of the law prohibits individuals from transporting undocumented immigrants who enter the country without inspection into Florida. However, keep in mind that if the USCIS, which is a part of the federal government, is saying that you, as an immigrant, you need to leave Georgia and come over to Florida to do your biometrics or do your interview, but yet the state law is saying, no, no, no. If you do that, or if your relatives come with you, your spouse comes with you to an interview, your relatives come, the taxi driver comes, bus driver drives you into the state, they are going to be subject to a felony charge. That's a serious criminal. So it's contradictory here, because the federal government is saying, come on over to Florida, come get your paperwork done, come get your background check done at the immigration agency. And the state is saying, no, 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 you can't come in. And if you transport the immigrant to come in, you're going to be getting a felony charge, right? That could include, for example, a spouse of a US citizen spouse or a permanent resident spouse who needs to come into the States from Georgia to attend an interview at the immigration office, the USCIS office in, say, Jacksonville, right? So that means that if that US citizen spouse is driving their immigrant spouse, who maybe came in undocumented, to the office for an interview, then that means that that spouse, that US citizen spouse, is going to get a felony charge. So here you can see where it's clearly contradictory. The federal government is promoting one, and then the state is prohibiting what the federal government is saying that the immigrant can do, or other individuals like the citizen spouse that I gave an example of can do. So because this, there's just no middle ground here. The federal government has to prevail. And if the federal government, if it's infringing on the federal government's ability to enforce immigration law, it's not lawful. So this is where I believe that they are going to prevail. Now, what they're asking for is they're asking for the court to put a permanent injunction on Section 10 of this SB 1718, the anti-immigrant law. Now, a permanent injunction means strike it. It cannot be enforced, which I definitely agree with. Now, another thing that makes this law very vague, unconstitutionally vague, meaning it's not permissible, is that the definition, so it prohibits, Section 10 of the law prohibits immigrants who came into the United States uninspected from being transported into the state. And it imposes a felony charge on anybody who transports that person into the state. So the immigrant does not get charged with a felony, but anybody who is transporting them into the state does. This could be a spouse. This could be a parent. This could be a relative, this could be a friend, this could be a coworker, and all of these examples are clearly stated in the complaint that these individuals are affected. Real lives are affected. I am representing clients whose lives are affected, and you're watching this. And you probably can relate to what I'm saying. You have probably left Florida, or you are staying on the down low because this law is affecting you, right? And so they're saying that this law is, it's too far reaching, right? For first of all, how is a citizen, how are we supposed to know who is inspected, right? Who is inspected, or who came in without inspection? How are we supposed to know who that applies to? It's too broad. Without inspection, any immigrant who has entered the United States without inspection could also include immigrants who originally they came across the border without permission. They came in without inspection, but later on they did gain status, legal status in the United States. Are they included in that? Based on the text of the law, it's saying that can be included in this, and that would just be, would not even make any sense, because here they are, they have legal status, but at the same time they're saying that the law says that anybody who entered the country without inspection is subject to this law, or anybody who transports an individual who came in without inspection is subject to this law. So that means that it could possibly cover individuals who originally came in without inspection, and then maybe they got asylum, maybe they got the T status. I represent these very same clients who they now have status here, but they originally came across the border without permission. And so that's what makes it too broad, because that doesn't make any sense, right? These individuals, they are now citizens, by the way. Some of them have, they originally entered the country without permission, but over time they even probably became citizens. But this law is saying that individuals like those could possibly be included under the law. Another thing here is that now we're going to have state officials harassing immigrants, checking documents, and going into things that they shouldn't be dabbling into. They're going to have to now take state resources. Law enforcement is going to have to take state resources to now become experts at enforcing federal immigration law. That's not even permissible. The state officials are not even supposed to be dabbling in federal law. They're not supposed to be trying to figure out who came in without inspection, who the law covers. And it could also mean that a lot of immigrants who maybe didn't even came in with inspection but are now out of status could be subject to the law as well, because now these officials are not experts at the law, and so they're throwing all sorts of people into the category of entering the country without inspection. And then how are you going to identify those individuals when they already have status? So then keep in mind that now it's going to require a number of people to start checking on each other's status. So normal, regular people, not only law enforcement, not only state officials, but if we all want to make sure that we're not charged with a felony somewhere down the line, we're going to have to ask our neighbors before they get into the car with us. We're going to have to ask our friends before they get into the car with us. We're going to have to ask our schoolmates and our coworkers what their immigration status is. We're all going to have to be experts at what counts as entering without inspection. And that is just too burdensome and is too broad. So I think once this is all broken down, it does struck from the law that individuals who are that this law that says that individuals who are traveling with, or transporting an individual who entered the country without inspection will be subject to a felony. It's too broad. So I'm really optimistic about this. It's going to be a matter of time, but we're going to see. So usually in cases like this too, the court may even issue a temporary injunction, which means they put a hold on enforcement of that law until a final decision is made. So that may be coming down the line. But the final relief that they're asking for is that section 10 of the law that says that individuals can be subject to criminal penalties for transporting certain undocumented immigrants be completely permanently struck from the law, and that it cannot be enforced. So it's good news. I think it's a good start, and I've read the complaint. I think it's thorough, and it presents valid arguments that are not just arguments, but they're true. It is contradictory, and it is against the Constitution. And the good news is that other laws, the Court of Appeals, 11th Circuit, which is right under the Supreme Court, has also found that laws like this, that where they affect the federal government's enforcement of immigration law, cannot prevail. All right. So now that I've talked about this lawsuit, I'm going to keep you updated. I'm going to just keep an eye on it. But now that I've talked about my piece, I'm going to welcome some questions. And the questions don't have to be just about the Florida anti-immigrant law, but it can be anything that's related. So go ahead, put your questions in the comments now so that I can answer your questions. All right. Hi there, Lindy. It's nice to see you. Go ahead, put your questions in the comments so that I can answer those questions. And it can be anything that's immigration related. Okay. I'm a 47-year-old, live in the US for 4 years, never work in the US. Can I file for citizenship? So no, now if you don't have permanent residence, you can't jump from having no status to citizenship. There's a difference between being a resident and a citizen, and you should never confuse the two, or it can lead to a permanent bar on you getting citizenship and even possibly deportation. So never confuse the two. Now, if you're here without status, first of all, you will have to look at gaining a temporary status or gaining permanent residence. Now, if your ultimate goal is to get citizenship, you're going to have to become a permanent resident first. Now, once you become a permanent resident, you're going to you have to meet certain time requirements. So usually the general rule is you have to be a permanent resident for 5 years. You have to be a person of good moral character. You have to be over 18 or over. You have to prove um, continuous residence and presence in the United States, a physical presence in the United States. So, and you have to show, I don't know, I may have said this before, but just in case, you have to show that you're a person of good moral character. If you can meet all the requirements, then you can go ahead and proceed with your application. Now, if you, and you can also apply for this, by the way, at the 4 year and 9 month mark, you can apply for citizenship. Um, so yeah, that's it though. You have to be a permanent resident first before you become a citizen. Which I see you said, yes, I have. So I think you're saying you are a permanent resident. Now, they don't look at whether you've worked. If you've been here, you haven't committed crimes that are going to reflect badly on your good moral character. That's fine if you haven't worked. Being here is not going to affect you. Now, you want to make sure that if you are supposed to pay taxes, though, that you pay those taxes before you file for citizenship, because failure to pay your taxes can lead to denial of citizenship. if you cross the border without permission, but you were in detention, can you plan to go to Florida? Will that affect you? So this is exactly what they're trying to litigate here. That is why they're trying to stop the law. Right now, they're saying that if you cross the border without permission, that you can't come into you can't be transported by someone into the state. So you won't face a felony charge, but whoever you're entering the state with can be charged. And then that's correct, right? The law is so broad that does this now are airlines going to have to check immigration statuses because they're going to be afraid that passengers on the plane are going to came in without permission and know that the pilot and the stewardess and the airline could also be subject to felony charges here. So these are the things that this lawsuit is trying to sort out here. Is that it's not safe to come into Florida right now, and you could face a higher risk coming into Florida if you came into the country without permission. And this is another thing that you raise, issue that you raise, right? Is you came across the border without permission. You were in detention, and now you're asking if you have to go, if you can go into Florida. Now, what if you came into Florida and your check-in point was an ICE office or a USCIS office in the state of Florida? Then you have to come in, and chances are you can't drive, by the way, because you probably can't get your driver's license legally. So you need somebody to drive you into the state to comply with the federal government to do your check-ins. So how is that going to work, right? And this is what the lawsuit is trying to resolve. It's that impossible choice that you have to make between cooperating with the federal government, or facing a higher risk of being harassed by law enforcement, having your relatives or your spouse or the person transporting you subject to criminal charges. So what I would say now is, can you plan to go to Florida? I would say don't. It depends. Once again, do you have to do check-in in Florida? If you have to do check-in, then you want to make sure you're doing your check-ins at the ICE office or at the USCIS, because if you don't, then they could come looking for you and then really deport you, and it would. So this is an impossible choice that immigrants have to make. Hi, can getting a DUI while on 2-year conditional affect removal of conditions? Now, I like this. I would say this is more on the complex side, right? Because I don't know the extent to which, what happened in this DUI charge. When it comes to criminal issues, it's so important to sit down with an attorney to go and have the details of the charge ready. Did you plead guilty? Was it a diversion? Did they dismiss the charges? What were the results of the charges? Also, it's so important to figure out the immigration consequences before you plead guilty. Because if the immigration attorney can work with a criminal attorney, or if it's an attorney that does both criminal and immigration law, they can really advise you about the consequences, and they can tailor their defense based on the consequences. So if they know that this is definitely going to be bad for you, they can do a plea deal with prosecution, negotiate to see if they can get the charge lowered or change it to something else or get it dismissed altogether. So, it's important to figure out those immigration consequences before you do any kind of pleas or plea deal. Now, when it comes to DUIs, one DUI alone is not going to render you inadmissible. However, how many do you have? Does a DUI now indicate that you're inadmissible in other ways? So this is where you should get legal advice, because it could possibly affect you just depending on what the facts are. But one isn't is one even one DUI isn't gonna affect citizenship, even. But what were the facts involved here? What's your history? Do you have a history of DUIs in the past, multiple DUIs? Hey there. So your I-485 was approved, 22 days. Congrats. No, but no welcome letter sent. Keep saying card produced since 22 days. Now, sometimes it can take even up to 4 weeks or more for them to send the card. Make sure you call, make sure they have the right address, and make sure that it is on its way, because it says card produced, but it didn't say card mailed. So find out, you really have to check with the USCIS on that to see where the card is. Are you going to save this live? Yes, I do save most of the live, so you can always watch it on replay. So I filed for VAW on April 10th and got the receipt on July 7th. What's next? Um, so it's going to be your biometrics notice. That's where you do the fingerprinting for your background check. And that comes around 2 months after you get the receipt notice. You're going to get that biometrics. Good afternoon. Travel to India on advance parole while adjustment of status is pending. Now, generally, the travel document is there to allow for travel during adjustment of status. Is it safe for you? That's where you need to make sure you consult with your attorney, or you do a consultation with an attorney. And this is where it's so important to have representation, because the attorney can guide you along the way, and they can really gauge the risk levels involved. Now, when, for example, if my clients have a history of crossing the border, or there's some kind of criminal issue involved, then the risk could be higher. If there are questions about whether there's a deportation order out for them in the past, then the risk level goes higher. So whether I advise, whether I advise, that it's safe, is going to depend on the risk level involved for that particular crime. Generally, if you don't have anything in your background, and your travel document is valid, usually it's not a problem. I just say, don't make it long, because you don't want to be outside of the country and get a denial, because that can be bad when you're coming in. So just in case, you're not counting on a denial. Of course, I'm hoping all is well, but you want to make sure you make your trip short so that you can go out and come back in before any kinds of decisions come through. So what if you put your papers in for asylum? This is also another thing that the lawsuit raises, is it still doesn't specify. It does not say that if you have papers pending, or if you file for immigration relief, or if you're in the middle of applying, that you are exempt from this law. It doesn't say that. So this is also going to have to be resolved by the court. And so for now, what we do have to err on the side of saying that even if you file papers, but you came into the country without permission, you are covered by this law. So if somebody transports you into the state, even if you have an asylum pending, but your original history says that you came in without permission, that law covers you. That's what it's saying right now, and that's not acceptable, right? Because it's clearly contrary to the federal government's the federal government saying, if you filed for your asylum while your asylum is pending, you're free to move around, you're free to work, you're free to do have that flexibility while they make the decision on your asylum. What happens when your case keeps saying actively being reviewed? Since March 1st, had put in for my spouse I-130 since last August. So it doesn't mean much. It just means that it's probably at the bottom of a pile on an officer's desk waiting for the officer to look at it. That can sit there for months and even years. So don't hold your breath on that one. It doesn't it mean that you're gonna get a decision tomorrow. You would hope so, right? And in the rare cases, that could be a possibility, but it usually just means that they have everything they need, and now they're ready to make. It just has to be reviewed. Sunshine, go ahead, call the office, and they will be more than happy to assist you to rebook that consultation. Um, all right, so that's going to be it for me today. I think based on the lawsuit that was filed yesterday and my reading of it, it's strong. They have a strong case here, and I think they're going to prevail. I would be very surprised if they don't prevail, if they don't win, and have this Section 10 of the law struck from the from being enforced. So if you apply for the T visa and you don't remember the names and anything, will it be a problem? So it no, here's the issue here, right? Is that I have what prevailed on cases where my clients have been so traumatized that they did not, or it was so long ago that there's a lot that they didn't remember. But the details that they did remember were credible, and it led to getting their status because it was credible. Immigration accepted their statement as evidence. However, if you don't remember a lot of the information and it's not credible, that's where it could be a problem, right? So you want to make sure, and this is where representation is key, right? Is um, getting guidance about the how strong your case is, and also getting guidance about what information is necessary to apply for the T status. But yes, I have had clients who have been so traumatized that, and this happens with trauma, right? Because I do work with clients who have been traumatized, and you would be surprised how trauma affects memory. If you yourself have been affected, been traumatized in your life, you know that a part of the trauma response is removing some things from your memory intentionally, just forgetting about it, and over time it just is not there anymore. But the basis of that trauma, the root of that trauma is still there. The memory of that trauma is still there. So, this is where it's important to just schedule an appointment. Let's talk about what you remember, what you don't remember, and determine whether you do have a strong case here to apply for T status. Can I apply and obtain the green card after I divorced for 4 years marriage, but never filed up any paper to immigration when I was married? So for VAWA, if your spouse mistreated you for VAWA and you got divorced, then you have 2 years. Once it passes the 2 years, your eligibility for VAWA has passed. But my whole thing is also spouses can traffic their immigrant spouse. And so if your spouse subjected you to things that you did not want to do, then for example, you do have situations where a person says, come join me here in the US, I'll marry you, I'm so in love with you, and then you get here and they turn into a nightmare. You get here, maybe they marry you, maybe they don't, but nevertheless they turn into a nightmare. They force you to cook, they force you to clean, they mistreat you, they force you to, do sexual acts that you don't want to do. They force you to work in their business. They force you to take care of their kids or other people's kids. That qualifies you here for relief under the T status. First of all, you didn't sign up for that, and they brought you here. They convinced you to come here with, they were fraudulent. They convinced you to come here. They're going to marry you. You're going to live happily ever after. And then you came here and realized that really what they had in store was for you to come here and do work for them, and be their maid. That does qualify you for an alternative relief here, which is the T status. So T visa still pending. Can you apply for the driver's license? No, in some states you can, right? In some states, even regardless of your immigration status, they do allow you to get the driver's license as long as you can meet the state's requirements, which sometimes is just to show that you are a resident of the state. Um, no, if you're, for example, if you're in Florida, you can't just take your receipt notice and go and apply for a driver's license. You probably have to wait for the approval. Why are you not supposed to check on your application status on NVC? So I've never heard that before. Now, what now, when you say check on your status on NVC, do you mean to contact them? If you contact them, then that could lead to a delay because they're pulling your file, they're pulling your case to be able to review it. And then when they put it back, it may be behind where it was previously. And that's the similar effect at the USCIS. That's why you want to use the case inquiry sparingly, unless it's justified, unless you've passed your processing times. You don't really want to be doing much digging because that means that your file could be, put backwards in the queue. So that may be where that is coming from. I mean, you can check the status in other ways. You can log into the NVC, but if you're trying to get them to speed up the process, then that may be a problem. How long does it take to get back the I-918 request? So the I-918 is for the U visa and the I-914 is for the T. Now, when we're talking about the I-918 request, it's going to depend on the I-918 is for the U visa for victims of crime. And when it comes to the U visa for victims of crime, the U certification is required by law enforcement. It's required to be done by law enforcement, and it depends on the agency because you have different agencies. You have you have the police, you have the Department of Labor, you have all sorts of agencies that do investigative agencies that do this. And so it's going to depend. Some of them are backed up. They're backed up by a lot, and they can't do they can't give you a U certification right away. But others, they may not be as inundated, and they can provide it pretty quickly. It just depends on the agency, and each agency works differently. So I've been separated from my abusive wife little over 5 years now, but technically weren't divorced. Can get remarried after approval of my VAWA case. So after the approval of the VAWA case, then you can remarry. Um, All right, keep putting those. These are really great questions. So put those questions in the comments and I will answer. If apply for VAWA and case pending for child has tourist visa, can she come to the US and add her application to my case? So, technically your child isn't supposed to come here with a B visa and then plan to stay here while she's walking into the country, like coming off the plane and walking into the country. So, I mean, it really depends here. This is a complex question, and it depends on what the circumstances are that are involved. Do I need to get a lawyer for for the actively reviewed case? So you should have a lawyer. You're never gonna catch me saying you don't need a lawyer, because I know that having a lawyer makes a difference. Now, if you don't have a lawyer, can you now seek a lawyer on the USCIS for the actively reviewed case? Not quite. Now, if it is taking too long and it is really gone past the processing times, there are options to file suits against the immigration to why it's taking them. You can't hire an attorney just for the having the actively review case. It depends on what the issue is. Is there an issue involved? That an issue where an attorney needs to work on it. So it really is up to you. You're never get an attorney, as long as it's in your best interest, but the attorney is going to have to determine whether it even makes sense at that point to get relief. How soon after you get your work permit from marriage-based I-485 do you get the green card? So there's no set time. It depends on the particular application and what's going on in that case. I've the usually I see the interview around 5 to 8 months after, if there's even going to be an interview scheduled. If there's no interview scheduled, you could see that green card anywhere from 6 months to a year after filing. So it just depends. If I get divorced in a different state from the one I work in, would that be a red flag? It could possibly. I mean, the immigration officers do look at details like that. And so if you filed for divorce in one state, but you were living together with your spouse in another state, it just depends on the facts in your case, but they can look at certain facts that you claimed previously to determine whether, where were you at this time or that time, and whether it does indicate that there were some untruths there. I had my interview last week. I was told I will receive an RFE. How long will the RFE come? So it just depends on what's involved. It can take anywhere from 2 weeks after the interview to up to even a few months. So they do have like up to 180 days to come up with what they need to put in the RFE. And so if it's really complex, you could see it, you could see it over 3 to 4 months. But if it's a simple RFE, maybe they want a copy of your birth certificate that you forgot to carry to the interview, then you could be looking at maybe 2 weeks. Now, if you have your online account too, keep in mind that you can log into your online account and you'll be able to see the RFE there before it even comes through snail mail. So that's a tip there. All right. So that's going to be it for me today. I will see you tomorrow at the usual time, around lunchtime, where I'll come with a topic and you come with your questions. These were excellent questions today. So thanks for your questions. I will see you tomorrow. Now, if you need to get in touch with me, you need to schedule an appointment, go to the link in the profile. On the video here on the screen on YouTube, Facebook, and Twitch, you'll see the number going across the screen. And you will go ahead and see the link to the link to schedule your own appointment, or the link to the website in the description of the video below. If on Instagram, you'll see the number in the on videos. So I have the number on number of videos, and you'll also see if you go to the link in the profile, you will see it on. You'll see the link to schedule your own appointment or go to the website there at Linktree. Doing the T visa, what documentation do you need? So the most important evidence is going to be your statement, your detailed statement. It's called a declaration, and this is one of the things I help my clients with, is their declaration, because that is the Remember that cases that happened 20, 30 years ago, you can get a T visa based on those situations where you are forced to do something you didn't want to do by someone else. Could be anybody else. Doesn't have that anybody else doesn't have to be a citizen, doesn't be a spouse. It doesn't have to be, it could have been another immigrant who didn't have status, could have been an employer. But the important thing is that the declaration has the information in there for the officer to make a determination that it is sufficiently detailed and credible for you to qualify for this relief. All right, so have a good day. I'll talk to you tomorrow. Bye bye.